this isn't a facial challenge. You're not saying any of these statutes are on this face
Correct.
unconstitutional. And your argument is that this is core political speech.
Correct.
So some crimes can be achieved solely through speech, though. Terroristic threats, solicitation. Why is that not what's happening here, as alleged?
Well, I think it requires kind of a detailed analysis, so if I may.
Sure.
All right, so the first thing we have to decide is whether or not, and we're talking about President Trump, we're not talking about the actions of others. We have to look and see whether or not that which has been alleged as facts is in fact core political speech, political discourse, protected speech at its zenith. I don't think there's any question that statements, comments, speech, expressive conduct that deals with campaigning or elections has always been found to be at the zenith of protected speech. What do we have here? We have election speech. So one must determine immediately whether that constitutes core political speech, and I suggest that it does. Now, does that make a difference ultimately? Yes, because the more core speech, the more it is protected, the less the government should be involved in restricting it. I don't think there's any real doubt about that. If I heard what Mr. Floyd just said, that if everything President Trump said was assumed true and included in the RICO indictment, and therefore now we're talking about true political speech, not alleged false, he could still be prosecuted for the violation of RICO.
For the overt acts as alleged. Let's say even the overt acts ran afoul of the First Amendment. He's saying that wouldn't be fatal to count one.
Because at that point, if there
could be some other thing they prove that's not alleged as an overt act.
Okay, that may,
as I understand
it, as I understood it as well. But what I'm suggesting is, if all of the overt acts are nothing more than core political speech or expressive conduct, and nothing else is alleged which is not protected by the First Amendment, then you have an insufficient basis for which he has been indicted, because he's being indicted for First Amendment speech and not for unprotected speech. And therefore, the statement that was made about if it were true, we could still use it as an overt act, suggests that they can prosecute true speech, which is what we're trying to get to here. It's the nature of the speech, the political speech, the heightened value of such, which gets this situation different than others, and the fact that it comes from then President of the United States. Going back to what was said in addition by the state, what the state claims is criminal here is lying to the government. That's what it said. That's the exact reason why in several of the Supreme Court cases, it's been found to be protected speech because it deals with the government, and falsity in sense of communication with or to the government is best dealt with through true speech, not through prosecutions, because prosecutions chill speech. And when it comes to political core speech, what you don't want is chilled. Fortunately, I have a co-counsel that is able to pull things up and help me inform the court until the computer shuts down. And looking at what Haley says, just to give you an idea of how the Georgia court, the Supreme Court, might look at this. There's a quote from Haley, and it says, "While there is no constitutional value in false statements of fact, such erroneous statements are nevertheless inevitable in free debate, and punishment of error runs the risk of inducing a cautious and restrictive exercise of the constitutionally guaranteed freedoms of speech and press. Accordingly, the First Amendment requires that we protect some falsehood in order to protect speech that matters." And I think that's what we're talking about here. To end this, and again, we're focusing on President Trump's conduct that at the time that he in fact is the head of the executive branch. There is references to this in Brown v. Hartledge, and I cited that earlier. A well-publicized yet bogus complaint on election eve raises the concerns that you may have some impact that would affect an election. But the preferred First Amendment remedy of more speech, not enforced silence, has special force. Underlying our dependence upon more speech is the presupposition the right conclusions are more likely to be gathered out of a multitude of tongues than through any kind of authoritative selection. To many, this is and always will be folly, but we have staked upon it all. And for speech concerning public affairs is more than self-expression. It is the essence of self-government, and that comes from Garrison v. Louisiana, which is cited also in Alvarez. Bottom line here is this. But for protected First Amendment speech, President Trump would not be charged in RICO or the other counts. Take out the protected speech, and you don't have an underlying basis for which to charge him. And since that violates the Constitution as applied to the charges here and his speech here and his position here, this is ripe for a constitutional challenge. One step further. If it's not ripe now and we get into intent, when does the court determine that? Do you determine that after we have a trial?
I think it would be the directed verdict stage.
Well,
right?
But would it? That's a sufficiency of evidence.
With all inferences, yeah, in favor of the state.
That's a whole question. I mean, do we go through the whole trial? God forbid there should be a conviction, and then we go back to trying to determine as applied? I'm suggesting the reason it's ripe now and the reason why we don't even get to a trial is because it's unconstitutional to force an accused, be it the President of the United States, former President, or anyone else, to stand trial on protected speech. And I think that's what Alvarez and the progeny previous to that and after say.